there is a hierarchy of law, and a hierarchy, being federal, state, and then, at the very bottom is your CC&Rs.
Yeah.
Meaning if the CC&Rs, the contractual obligation is inconsistent with federal law or state law, they're going to be unenforceable.
Sure.
And that doesn't mean that the association isn't going to try to enforce them against you.
Right.
It simply means that if that happens, you can fight back very aggressively. And so sometimes, the association, and going back to sort of what we talked about before with the personality types, they might just be ignorant, the incompetent. They just don't know what the federal law is or the state law is. And they're trying to enforce stuff that they can't enforce. So you get hit with some sort of violation. And the simple pushback is, here's federal law or state law, go kick rocks.
Yeah.
I'm Luke Carlson, and for almost 2 decades, my law firm, L.S. Carlson Law, has been at the forefront of defending homeowners against overreaching HOAs. We're not just leading the charge, we've created the go-to playbook on how to fight back effectively. Join us as we delve into the world of HOA disputes, sharing insights from our extensive experience and landmark victories. Throughout this podcast, we'll bring you in-depth interviews, demystify complex legal principles, and provide practical tips to safeguard your rights. While the information provided shouldn't be taken as legal advice, our aim is to empower you with the knowledge, strategies, and real-life success stories needed to navigate and overcome the challenges posed by overreaching HOAs. Hi, I'm Luke Carlson of L.S. Carlson Law. Welcome back to the show. Today, we are focusing on disputes in the context of homeowner association law. Now, if you recall, last week, we did a whole series on personas. What are driving these types of disputes from a personality perspective? And now we're shifting the focus really on breaches. What type of breaches do we see? What sort of misconduct do we see? Today, I also have Jenny on the show. Welcome.
Thank you for having me.
And Marty.
Hello.
Welcome
Always a
back.
pleasure. Thank you.
It's a pleasure to have you. So let's see what we have today. Marty, how would you like to start? I like your guidance on
We're going
this.
to go through the typical dispute types that you've seen over the years. And the first one we have up are CC&R violations.
Oh, those are fun.
Yeah.
Those are my favorite.
So I think the best way of getting started is what are CC&Rs, defining what CC&Rs are, and then going from there.
Yeah, so CC&Rs, covenants, conditions, and restrictions.
Nailed it.
Yep. I want to go slow on that. But those are CC&Rs. I mean, most people call them CC&Rs. They're also called governing documents. They're the documents that really govern the relationships within the community themselves. So it's a contractual relationship, often between the owner and the board or the association. Because if you recall, the association itself is an entity, a legal entity. Yeah. So when you buy into a community, you will be bound by these governing documents. So they're very important documents. I encourage everyone before they purchase in a community to read them. Most people don't. That's fine. But realize you are bound by them once you buy a home.
What are some of the things that typical CC&Rs have in them?
I would say CC&Rs really cover all the things that drive the community and ensure that fair market values are maintained. So what you're looking at is, first and foremost, what are the responsibilities of the association? What is the association supposed to do? And what I mean by that is, there's very specific things that they're responsible for, such as common area maintenance. That's a big one. So when you go to a community, there's often green belts, maybe there's tennis courts, pools.
Yeah.
The CC&Rs, it's the document that puts the responsibility on the association to maintain that area. If you live in a condo, you're going to have elements in the condo that are common area. So, for example, the roof, that's common area. So as an owner, you're not permitted to go on the roof and maintain and fix a hole. You're not permitted because the CC&Rs put the obligation on the association.
Sure.
So maintenance responsibilities, it will also maybe identify fines, penalties, sort of what color your house is supposed to be.
Architecture.
Yeah, that seems to be the big bone of contention is that everyone, whenever I hear about CC&Rs and people, why they hate HOAs, like, I can't paint my house a particular color. That's always the first grievance I hear.
You get to pick 4 different colors of brown, 4 different variations of brown.
Right. But, conceptually, the idea is we're doing this because we want to maintain a harmonious community.
And prevent the pink house.
Yes, exactly. Or the fuchsia, pink, zebra.
Whatever it is.
Yeah. So, there is a utility to it.
What about pets, noise, business activities? All that kind
nuisance, they define nuisance typically. Pet restrictions, rental restrictions. landscaping restrictions, what you can and cannot do. Sometimes, you have to have certain plants. You can't have anything.
Especially in California.
Yeah, especially in California.
With like drought restrictions
Yes.
and things along those lines.
Well, that becomes interesting, and there's tension between sort of what the state law is regarding, sort of drought-resistant plants and what the association can and cannot do in terms of barring that.
That's a great segue to define, I guess, the CC&Rs are under local law. So there's federal, state, local laws, and then CC&Rs are under that. So to the point where if it goes against any of those, the hierarchy, then those CC&Rs are, I would assume, null and void.
Well, I think what you're saying is you're really looking at enforcement. So there is a hierarchy of law, and a hierarchy, being federal, state, and then at the very bottom is your CC&Rs.
Yeah. Meaning
if the CC&Rs, the contractual obligation is inconsistent with federal law or state law, they're going to be unenforceable.
Sure.
And that doesn't mean that the association isn't going to try to enforce them against you.
Right.
It simply means that if that happens, you can fight back very aggressively. And so sometimes, the association, and going back to sort of what we talked about before with the personality types, they might just be ignorant, the incompetent. They just don't know what the federal law is or the state law is. And they're trying to enforce stuff that they can't enforce. So you get hit with some sort of violation. And the simple pushback is, here's federal law or state law, go kick rocks.
Yeah.
And really...
So that goes back to who starts the CC&Rs, who maintains them. And typically they have counsel too that's intrinsically involved in all this stuff. And then how do you migrate that? I have so many questions.
Yeah, so let's go back to the origin story of associations. Typically there's a developer that comes in. The developer develops this piece of land, and as part of the development project, they will record a set of CC&Rs, and they'll file it. You typically are recorded with the county.
Are those pretty like boilerplate template kind of a thing?
The bad ones are, the good ones are not. The good ones are thoughtful. Someone has, given it intellectual rigor, has thought about the community and says, hey, if we're going to design this master community, how do we want it to really function? The bad ones, in my mind, that create a lot of the problems are the ones that are boilerplate, that someone just copy and pasted, and some of the provisions might not even be applicable. So you got that issue. So let's say a newer community, you get a really good attorney who develops customized governing documents. That's great. That can be actually very beneficial. It clearly articulates the responsibilities of all the parties and sets the community up for success.
So they usually work with like the architects and of the community.
They
as well. Okay.
Yeah. Sometimes it's a huge collaborative effort.
Yeah.
And you produce really good governing documents that make sense. You can read them. And then you have the other set, which are horrific. I call them Frankenstein documents because they copy and paste from all these other documents. So internally, if you look at them, they don't make sense. Like the defined terms don't add up. There's a defined term that was never defined. They use language which is inconsistent.
Because it's all piecemeal.
They pieced it together to cut corners.
AICC&Rs.
Right. I mean, 100%.
I haven't seen any of those just yet.
Oh, just you wait.
But they'll probably
it's coming.
Yeah.
What's worse though, and what you see, which I think is tragic to an extent, is where you have a homeowner who's living in a beautiful community, and they bring in CC&Rs that were drafted on a typewriter from like 1979. I see that consistently, and I say it's tragic because it's not that hard to hire a good lawyer to update your CC&Rs. But what you're doing is you're forcing the homeowner and the entire association to run on these antiquated documents that are typically very draconian and just set up the entire community for problems. You're going to create friction points with a bad set of documents. So my recommendation always, and I'm not an association lawyer, but what I advocate for is, associations should be updating their documents. They should be, identifying ways to customize them, make sure that they fit the actual community. Because you want your governing documents to be consistent with the DNA of what's happening.
Sure, because I could see, look at we live in a plethora of go to RSM and everything was built of the 80s and 90s, and the architecture has changed, the drought tolerant plants, the whole thing has changed. So I would assume these should somewhat migrate with the times, which leads me to another question, which is how do you modify those? Who brings it up? What if, does the homeowners vote on it?
Yeah, it's typically the board, and they typically have good associations have good counsel. It's like in-house counsel. And there's different rules and procedures to amend, and every set of documents are a little bit, they're different, right? There's different procedures, but the board and the counsel who's overseeing the board or who's directing the board or the attorney for the board should be making those recommendations. If they see, hey, were drafted in 1979, maybe we spend some bucks and update these.
When you see a lot of communities, ours included, that have special fire hazard certifications, or lack of fire hazard, I should say, when we have the succulents and the drought-resistant plants, things like that, I feel like are always causing people to update the CC&Rs.
Yeah, I would say that if you have pressing safety concerns that are open and obvious, and there's ways to modify, and ways to modify being within the restructuring of the governing documents, yeah, that could prompt it. What else could prompt it is, they just outgrew the CC&Rs. They required a certain a build type, and that build type no longer exists. That might be a reason to do it. Or there's ambiguities. There's ambiguities in terms of what the CC&Rs are actually saying, which are causing conflicts. That could be, what is the proper way to enforce? How do you enforce an outstanding violation? So there's areas that will typically create friction because there's an ambiguity within the document. And when you start to see that over and over again, that might be the time that says, hey, maybe we should change this and clarify the
Especially with
obligations.
lead paint in apartment complexes, things like that.
Right. Yeah. So to your point, yes, I think a lot of things will trigger that event, and sometimes it is derived from safety or lack thereof.
Yeah.
What's it? Okay, so I've been trolling Reddit for good stories and things, and I always see, I just went through my bylaws and I didn't see X, Y, and Z. So what's the primary difference between CC&Rs and bylaws? Is there a difference, or are they interchangeable?
So I like to think of bylaws as corporate governance. That's really how the board should be governing itself. I mean, it goes into proxy voting. It's more specific in the mechanical nature of association, just governing association.
Interesting.
So this is how it's supposed to be ran.
Correct. It's a little bit more technical. It goes into, like I said, voting, proxy voting, how meetings should happen. It's more of the technical handbook.
Whereas the CC&Rs really cover how the community should look and
it's more functioning as a whole.
Okay.
And typically, the problems that we see derive from a breach of the CC&Rs. More so than a breach of bylaws.
Processes.
Now, violation of bylaws does occur where you have a board that's just not doing anything. There's no corporate governance. They're not doing minutes. They're not doing meetings. They're not holding elections. Then you probably have a variety of breaches that arrive from maybe the CC&Rs and the bylaws.
That's usually on your side, because you're defending, or you're on behalf of the homeowner. You're saying that the board is not, functioning in terms of the way they're supposed to, according to the bylaws.
Correct. And that becomes a violation of the bylaws.
Sure.
So
interesting. Thanks for the clarification.
yeah, you got it. Actually, that question comes up quite frequently. So, all right, what else do we have, my friend?
So we went through, I think we should just take a look here at some of the common types of violations. So we list them here. So some would be architectural violations, landscaping issues, nuisance, unauthorized use of property. That's probably pretty frequent as well.
Let me go through these point by point because they get interesting. Architectural violations, you have ones that are legitimate. Someone decides to paint their house zebra. Okay, you can't do that. It's clear in the CC&Rs.
Yeah.
The issue that you run into, though, is where a homeowner does something that seems to be permitted by the CC&Rs. But again, going back to that ambiguity, they see other neighbors who have the same feature maybe. Maybe it's a fence. Maybe it's a monument. Maybe it's some sort of aesthetic improvement to the home itself. They didn't run it through the Architectural Control Committee, which you typically have to do for certain things.
Yeah.
But there's an ambiguity as to whether you did or did not have to do so. And again, other property owners have the same feature, and all of a sudden they're getting violation notices.
So perhaps it's like, my neighbor did their house pink, but these neighbors did theirs like Barbie pink.
Right.
That one's permissible, but it's still not in the code. So it's
Or maybe
selective
they got
enforcement.
There could be selective enforcement, or there could be just a lack of intelligence driving these things. Maybe the board isn't aware that they're allowing 15 other people to do something, and it just happened to be the case that someone happened to notice yours. So architectural violations are interesting. Sometimes when they happen and you get a violation notice, they're legit. But to the extent that, they're in that gray, sort of gray area of the law, you may want someone to take a closer look. So that's architectural violations. Landscaping issues are somewhat similar to architectural on occasion, but again,
Maybe you should share our friends that are going through this right now without saying names.
which friends?
I said without saying names. Our San Clemente friends that built a
Oh, okay. So yeah, that's
because this ties in
yeah.
landscaping and architectural violations.
Without question, that exists outside of an association.
Okay.
That's entirely that is a non-association street, and that's
just a
city issue.
City issue,
Yeah,
okay.
it's an unfortunate issue, but that's actually more of a contractor dispute.
Okay.
To be honest.
Pins
But
and needles over here.
yeah.
Give them a little brief description.
Yeah, so essentially what happened is they built out a very cool deck. They relied upon a contractor to do so, and the contractor failed to pull permits, allegedly, and failed to do the proper setback. So now it got red tagged. It's a whole thing.
They did tear down the whole deck.
They're most likely going to have to. Now, that's public. I mean, not public, but that's outside of an association, and they're not bound by any CC&Rs.
Okay, so this has nothing to do with HOA.
Correct. But I guess to relate it back to an association issue, I mean, that could be very similar in the sense that you would have someone build something out and not go through the Architectural Control Committee in the first place. And if you fail to do so, the Architectural Control Committee might have the authority to come in and ask you to tear it down.
So let me ask you this: in the case, let's just go back to that deck issue. Let's just say that the city says it has to be within, it can't be any closer than 30 feet to the end of the property line.
Right.
But the CC&R says it's not allowed to be. It has to be 45 feet. So it has to be. You have to have a bigger gap between the deck and the end of the property line. But that goes against, I guess, what the local law says.
Well, I guess if you take a look at, you got to get a permit ultimately, right? So you got to make sure you can get a permit. If you don't pass permit, it's not going to work in the community.
Regardless,
Sure.
Yeah. Now, if the city requires 5 feet and the association requires 7 feet, the association will probably win that because they can still dictate certain things.
Sure.
Right now, what they couldn't do is say 2 feet. A 2
They couldn't
foot
go
setback,
under the city. Yeah.
because that would undermine or undercut the city.
Sure. Yep. That makes sense.
But to go the other way on it is fine.
That's what I was getting at. Okay.
Yeah.
Very good.
Yeah, but that's a good question too. But yeah, the Architectural Control Committee, though, it does have a lot of power. Normally, when you do something, it's advisable to go through the process.
And I would assume the best practice would be get it in writing.
Always get everything in writing.
Yeah.
Yeah, there's no handshake deals in this world.
Yeah.
Yes.
So
The
you have
licensed contractor and permits.
Well, that's
Yeah.
you got two things there. You got a contractor who's coming in, but you also have to run things through the association. And you got to be wary too of contractors who say, "Don't worry, I'll take care of all the association stuff," because that is a technical process. You might want to be up in that mix if you can. I wouldn't just defer to some contractor.
at
Yeah.
least get CC'd on it.
Well, follow, see what's happening.
Yeah.
Because that could, an association could legally torpedo your situation very quickly if they wanted to.
Absolutely.
Are architectural control boards, are they the same as the actual board? Or
Sometimes it's a subset.
Okay.
It depends on how big the association is.
Do you have to be elected in order to be on that board?
It would have to turn on how the CC&Rs are set up.
Okay. Well,
Sometimes yes, sometimes no.
Interesting.
Yeah.
Would that be under the CC&Rs or the bylaws?
Likely be under the CC&Rs.
Interesting.
It could be under
See,
the bylaws.
I'm learning.
It could be under the bylaws.
Look at you. I love your interest in this.
I've seen it under both, actually.
Oh, okay.
Yeah.
Interesting.
Rightfully or wrongfully, I've seen it under both.
Perfect. All right. Let's keep dragging
All
along
right.
here.
Nuisance complaint. Nuisance is interesting. Normally, all CC&Rs have a nuisance section. What is really defines a nuisance? Nuisance is typically common law nuisance, which is noxious noise, smells, odors, activities. It's typically pretty vague.
Yeah.
But yeah, if there is a nuisance, let's say someone is jamming out, partying
It's loud music,
24/7,
yeah.
that becomes, you could allege nuisance, but you could also likely allege breach of CC&Rs. Because the other thing too, and I didn't mention this, the CC&Rs, the contractual relationships, run not only between the individual owner and the association, but it also runs between owner versus owner. So think of that. If you're engaged in a nuisance, I can actually go after you for breach of contract. It's a breach of contract claim against you for breaching the CC&Rs. Because there's been an agreement amongst the community that no one's going to engage in a nuisance. But now you are. Well, at least I'm alleging that you are. So now the claim, I would have standing to bring something against you for breaching the CC&Rs.
So that's how neighbor disputes get pulled into
Yes.
HOA.
And then where it gets
issues.
it gets interesting though is, let's say you have a neighbor who is, let's use the party example because that does happen. They're partying all the time.
Yeah,
It's
they're just
loud
wild.
music, 3, 4 in the morning. So that's an open and obvious sort of violation of the CC&Rs. But let's say that person is friends with the president and the association is taking no action to
Say
enforce.
the president's at the party.
Maybe so. Yeah, okay, that's a good one too. They're enjoying it. They're partaking. They're turning a blind eye to the nuisance. And you're the neighbor who's being impacted. The quality of life is being impacted quite a bit. So you as the owner, you could bring a claim against the neighbor for the nuisance and the breach of the CC&Rs. Theoretically, you could also potentially bring a claim against the association for failure to enforce. That might be some sort of, it's almost like a variety of preferential treatment or selective enforcement. So that gets interesting.
But you'd want to document this, I would assume.
Well, yeah. I mean, in these scenarios, typically you have police reports because the neighbors will call the police out several
Right.
times. The police will come out, have to shut down the party. More sophisticated neighbors will have noise. They actually can calibrate
Decibel
how much,
meters.
decibel
Yeah.
meter
Yeah.
readings. They'll have video of it. They'll have video of the parking, and they show sort of a consistent pattern and practice of this violation. But yeah, so it'd be almost a double prong attack: one against the neighbor, one against the association.
Interesting.
Slightly different set of
Yeah,
claims, but
makes sense.
lease and rental restrictions, that's a hot topic. Some associations bar short-term rentals. When short-term rentals were very popular, a lot of associations shut those down because that does impact fair market value.
Sure.
Yeah.
If you have a community which is just a hotbed for 3-day rentals, that doesn't bode well for your community.
But what's the latest thing that everyone's talking about? It's the rehabs.
Or rehabs are big too.
Yeah.
So that goes back to type of use.
Yeah, so there's a lot of litigation surrounding that area. And, we haven't really seen it that much at this firm, so I don't want to opine. I don't think we've ever taken on a case like that. But I know that there's tension between the policy of wanting these rehab homes and the potential nuisance that it could create.
Yeah.
But I think
Well, danger, arguably. I know in Laguna Beach,
Ar-
that was always the
arguably though, and unless you have something tangible, it's hard to allege that that's an actual nuisance unless something is happening.
interesting.
So if you have a group of people moving in and it's a rehab, right? But they're complying with the CC&Rs. There's no excessive noise. The amount of people who live in the house doesn't violate the CC&Rs either.
Parking. Yeah.
Parking is fine.
Yeah.
I mean, what is the actual damage at that point? There's a hypothetical. There's a
Right.
perceived like, oh my God, these are fill in the blank. But unless you can actually show something, unless you can actually show criminal activity of some level,
Right. People don't like seeing the ankle bracelets that happen sometimes.
correct. But that in and of itself isn't
Right, is
something you
not-
can take action on.
Yeah.
So could the majority of homeowners raise a say we want to amend the CC&Rs or the CC&Rs to not allow for these types of
See, that's the question I do not know.
Yeah.
Because I don't know if the policy that favors these types of homes, I don't know that I don't know the tension between the two. I don't know if some sort of federal or state.
Sure.
law
So it goes back
would
to the
override-
hierarchy
Yeah.
there.
And I just haven't been involved in a case like that.
That makes sense.
So I
That's
don't
very
know.
interesting.
I don't know offhand. So, but good question. Pet restrictions. Yes, you can have pet restrictions. They happen all the time. How many dogs? Size of dog, type of dog. And that's also why I encourage people to read the CC&R, especially if you have pets. Because I've seen it before. People buy in homes, they have like 4 dogs, and all of a sudden they start getting violation notices. So pet restrictions is a big thing, and that's a lot of tension there.
What about consequences of violating CC&Rs?
So it's interesting how this is framed. You have fines and penalties. How are they applied and escalated? So you were looking at the owner who's in a position of the violation, right?
Mm-hmm.
So yeah, I mean, if you're violating a CC&R, let's say it's you painted your house the wrong color. What's likely going to happen is there's going to be some sort of notice. Hey, please paint your house the right color. Hey, by the way, please paint your house the right color. You'll get a series of those. Eventually, though, that will culminate in some sort of hearing. We need you to come and explain to us what you're doing.
Yeah.
In conjunction with that, you might start to see fines. Sometimes it happens before the hearing. Sometimes it happens after the hearing. But at some point, if you don't do anything, there's going to be fines that start to come in. And then at some point, the association might take legal action. Now, if it's California, the flow might look like a demand for ADR first, alternative dispute resolution. That's under the Davis-Sterling Act. That is the association sharpening its knife to come after you. They are contemplating a lawsuit, most likely at that point in time. But before they seek court intervention and they file a lawsuit, they're going to attempt to do what's called ADR first, which is mediation. The reason they're doing that is they want to preserve the right to attorney's fees. They want to come after you for the attorney's fees, in addition to you painting the house back. So that's typically the first step is ADR. You go to ADR, you tell them to go kick rocks. I can promise you a lawsuit is most likely coming down the pipeline. And listen, if your house is the wrong color and it's crystal clear in the CC&Rs, you're going to lose.
Does the CC&Rs always outline the fines and when they're to be levied?
Not always. Sometimes it's on a separate document. Sometimes there's a fine schedule that's produced. Sometimes that fine schedule is changed. I've seen it cut every different way.
But between the CC&Rs, the bylaws, the overarching documentation of the community should outline the fees, fines, and when they are to be levied. Yeah.
And what's interesting when we talk about violating the CC&Rs, from my perspective, I'm always looking at it from the other angle. How is the association violating the CC&Rs?
Oh, interesting. Yeah.
Because, of course, you have situations where the homeowner is violating legitimately and the association is taking rightful action. But most of our cases is the reverse of that. It is where, the association is engaged in some sort of misconduct. And the most common form of CC&R violation, I would say, from an association is specifically failure to maintain common area. I think that's one of the biggest ones because that one has, I would say, the biggest financial impact on homeowners. If you think about it.
They have a pool that's not maintained or a park.
No, actually, you look at it in maybe two ways. One, in condos.
Roofs.
If the common area roof is not maintained, you have water intrusion. So that's a huge issue. Part two, though, is piping within the common area. Because you have to remember, you own sort of the interior of your unit, but there's walls, and in the walls there's all these pipes that are running. If those pipes are not maintained and a pipe bursts, or if there's some sort of failure to maintain over a period of time, and that pipe bursts and your unit is destroyed or damaged, you would have a claim against the association for failure to maintain a common area, which really is just a breach of contract claim. So I see that all the time. That's a very common one. On the freestanding home side of things, often what you see is a failure to maintain a slope or water drainage. So there might be water drainage in a common area green belt, but because they didn't maintain a drain or they never put in a drain, the soil is very saturated, and all of a sudden you have water intrusion events in the home. So that's a big one too. And again, if you want to pinpoint what that is, that's a breach of contract under the CC&Rs for a failure to maintain common area. And typically the standard is failure to maintain and repair. So, maintenance, if you look at the maintenance, the word maintenance, I mean, really what that should mean is inspection as well. I mean, the association should be inspecting these things on a reasonable
Regular
basis. How often do you inspect the roof? And the response is, well, we never, 20 years, we've never looked at it.
Right.
Okay, well, now you have breach of contract, but you probably also there have a negligence cause of action in addition to a breach of fiduciary.
In a good HOA, it seems like there should be a cadence for inspection.
Absolutely. Yeah, and well-functioning HOAs have that cadence. They have a maintenance schedule. They're routinely out there, and they defer to experts. They say, hey, I'm a roofing expert. I recommend that we see your roof once a year. And they sign off on it. It's not the association doesn't need to necessarily understand roofing.
Sure.
Right.
They
of
don't need to
course.
understand piping, but they need to find an expert who does and defer to them. So,
And get everything in writing.
all right, what else you got, Marty?
That's interesting.
Legal ground for homeowners.
Yeah. So I think we covered that. So at one point I think we covered that well in terms of you just discussed it when the association goes against the CC&Rs. That's when you typically have the legal ground.
Yeah.
And that can be in the form of failure to maintain. That could be selective enforcement. That could be a number of things. I think that we covered here. So what about the DIY, right? We having some sort of a dispute, and we've covered this in some of the other podcasts as well, but I think it's worth rehashing here in terms of a CC&R violation. What are the first steps that you would take as a homeowner that wants to try to solve this on their own? And then at what point do you cross the line where legal intervention by way of an attorney is necessary?
Okay. So the first thing I would look at as a homeowner or as an owner is impact. I think there's two types of impacts with this. It's financial impact, and then you have quality of life impact.
Sure.
So that's sort of your barometer, if you will. That's sort of how you're measuring what's happening. Is the breach, how does it impact you financially or your quality of life or both? And sort of that's your gauge, right? And if neither of those buckets are being impacted, or if you're not feeling any impact because of it, the question then becomes, do you really want to do something about it if it doesn't really matter? You don't necessarily want to be a homeowner that's always causing issues either by saying everything is wrong, and that in and of itself becomes a situation. But to the extent that you're having some sort of financial impact or quality of life impact, my recommendation is first and foremost, always document. Make sure you're documenting what's happening. Make sure you're, if it's video, take video, pictures, journal. Just write down, hey, today this is what I experienced. If it's a water intrusion event, make sure your experts are out there, that they're articulating what has happened, because evidence is going to be very important. So that's the first thing. You got to come to the table with something. But at some point, you're going to have something to bring to the association. So it's not just you saying it, but you reach out. And, at least in California, a great method to do so is the informal dispute resolution process. We've talked about that before.
Yeah.
But essentially what that is it is a correspondence to the board or to the management company identifying you as the owner have an issue, and you would simply like to talk to the board. And you articulate it as a request for IDR. And that should get you there.
Is it
That's
important to
usually
use
the red
that
flag.
verbiage?
Yeah.
Is there magic language? I suppose yes. I think you should use it. I mean, if you're going to do it right. Say, I'm requesting IDR. Sometimes I see homeowners, they essentially engage in IDR without ever saying IDR. Like they've opened up lines of communication with the board. They're talking to the board president. The directors have come out to the property. In a sense, that is a form of IDR.
Yeah.
Right? But
understood.
You just got to open up those lines of communication.
But usually if you're going to specify, IDR in your body of your email or in the subject line, it usually raises the flag, they should get their antennas up at least.
Right.
It shows a level of intelligence and sophistication when presenting the dispute.
Right.
Right. And I think it is somewhat of a buzzword, and it's a precursor maybe to something bigger that might happen.
Sure.
Yeah.
So I agree. I think it's a red flag from an association perspective. So I would encourage you to use that term IDR.
Yeah.
If you're in California. At some point, you're going to go to the board. You're going to talk to them. And a really good board is going to see what you're saying and actually think about it and apply intelligence to it and try to problem solve. I think that's a good board. A bad board, on the other hand, is going to say, go kick rocks. We're not listening. You're wrong. I don't care that the roof is leaking.
Or just no response at all.
Or no response at all. Yeah. I mean, that's equally bad in my mind. So I think that's the threshold. Are you getting traction on your own? If you're getting traction on your own, avoid a lawyer.
Yeah.
Because with lawyers, you're just spending money. And if you can resolve a dispute without spending money, that's a win.
Yeah.
Now, that's coming from a lawyer,
Yeah.
right? But I see a lot of situations, and we consult with clients all the time, where we actually recommend before you hire us, try this first. And if it doesn't work, you know where to find us. And I think that is the tipping point. If it does not work, if your informal efforts are not working, you're not getting traction, you're hitting your head against the wall, okay, then you bring in the advocate.
Yeah.
And that's when you bring in firepower. That's the triggering event.
But they should also, I mean, it goes without saying, they should be very familiar with their CC&Rs and bylaws ahead of time and be able to reference the grievance right there.
So I think that's tactic. How do you approach a board? How do you do it in a meaningful way?
Yeah.
First and foremost, you've got to take the emotion out of it. And that's hard to do. And I understand why it's hard to do, because this is where you live. Your life has been turned upside down because of their screw up. So your natural reaction is you're going to be mad.
Yeah.
I think that's absolutely normal. But as much as you can, compartmentalize that and go to the table in a much more clinical way. And it might look like this. I'm looking at the CC&Rs. It says that you're supposed to maintain the common area roof. My expert here says that there is a massive hole in the roof. As a result of this massive hole in the roof, here's the damage I've suffered.
And here's the financial.
Yes.
Yeah.
As opposed to a yelling and screaming,
Sure.
and your life is horrible. I believe you get more traction with a clinical approach.
Yeah.
And listen, they
It's
can.
just good advice in life.
Yes, I think so. And they might be theatrical. They might be bombastic. It depends on the personality type. Going back to our other episodes, yeah, you might get a tyrant. You might get an incompetent person who just doesn't know what you're saying, doesn't even know they have CC&Rs. So you might hit a lot of roadblocks. If you do, that's fine. Just shut down the meeting and move on, because there's another outlet. That's where you bring in the advocate.
Yeah.
Don't hit your head against the wall if you don't have to.
Would you ever recommend the homeowner go right to the association's lawyer
No, because
to get an adult in the room, basically? Just saying, hey, these guys don't know what they're not treating me properly. They're ignored everything.
Well, okay, listen, I'm pessimistic, and I am not the right person to ask, because I always see the worst in situations when it comes to that. I just don't trust association lawyers, because I've seen the bad that happens. Now, don't get me wrong. There's a lot of really good association lawyers that I have tremendous respect for, and they're out there. I've seen them. They do good work. They actually really help communities. My concern with what you said, though, is you take an individual owner who bypasses, circumvents the board, and goes to the lawyer. And the lawyer says, yeah, I'm absolutely going to help you. We're going to get this resolved. Just sign this document real quick. And it's some sort of release. And they just shot themselves in the foot. I've seen clients come in that ran that play, and I'm sitting on a full release of all claims. I was like, why on earth did you do that? Like, well, they said that they would get, pay at least $1,000, but, obviously it's $50,000 or $100,000 claim. I said, well, you just waived every single right that you had.
Yeah.
Right. And that's very unscrupulous, but that would be my concern doing that.
I see.
So it's important to follow the proper channels.
That makes a lot of sense.
Yeah. So I guess to answer your question differently, yes, go to the lawyer, but be careful, keep your guard up, and you are in a way assuming a risk in doing so.
Don't
proceed with caution.
Don't sign anything.
Proceed with caution.
Don't agree to anything.
Anything you say can or will be
Yes. Just be careful. That's all.
That's really good advice, actually. I would have not picked that one out. All right. We're going to have a couple Reddit rapid fires for you. Jenny, you want to read a couple of these things? And then, we'll go from there.
Okay.
All right.
Let's see what we got.
Okay, first one. My HOA has been charging me a fine of $50 per day for a dog I don't have. I got an attorney to write a letter on my behalf last March, and they didn't drop it. I just got a bill for over $20,000 in fines. They are accusing me of having a pit bull when I have a pug and a Chihuahua mix. I've never gotten along with the board members. They are doing whatever they can to get me to move. What should I do?
Okay. First, I'll frame this out in California. I'll assume this is California. That just makes my life easier.
Yeah.
And I can only really opine on California, so I have to do it that way. So this is interesting. $20,000 in fines seems very excessive. That seems insane.
Do they have fines that that grow and grow and grow and grow? Like first violation, it's 50, but then we're at day 30 now.
Right.
Now it's going up to 100, but yeah.
Okay, so the first thing I wonder is, a lawyer wrote a letter. Now, my bet. So again, California, you read a letter. A letter in and of itself might be entirely ineffective because there's no consequence for the board or opposing counsel to just ignore the letter. So just because your lawyer wrote a letter doesn't mean that they have to respond. You put no legal obligation on them to do anything.
Okay.
So two things might have happened. One, opposing counsel, association counsel received your lawyer letter and threw it in the garbage. That's part one. That could have happened. Part two, though, maybe that lawyer called your lawyer and strung that lawyer along just to kind of kick the can and take no real action. Lip service, if you will. So I would go, if I saw this fact pattern, my recommendation would likely be a very aggressive ADR play. Almost flip the switch, or what do they say now? Flip the
narrative.
No,
Turn the tables.
flip the script.
Oh, flip the
yeah.
script.
That's
Hey,
the new way to
it's
say
all
it.
the same.
Yeah,
same.
that's what the kids say. You flip the script on this one. You know, if this is true that they don't even have this dog and they're being fined, now you have harassment. You have selective enforcement situation. I mean, this is targeting potentially. So you would likely be able to come at them in an offensive posturing. Once you tell them unequivocally, hey, this is why you guys are dead wrong, and this is why now we're coming after you for this form of harassment. It sounds like they may have weaponized the fee schedule against this person,
Yeah.
Sure.
right? And now I would say you'd get leverage through an ADR play demanding alternative dispute resolution. And now you're seeking not only for them to drop this thing, but you want reimbursement for your attorney's fees. Why? Because it's absolutely insane that you're hiring a lawyer to deal with this.
Got it.
So you might
I
be able
like
to
it.
jam this down their throats.
Like
Nice.
it. Like
That'd be
it.
my humble opinion.
I kind of like the next one.
Okay.
A couple of years ago, the HOA recommended that we replace our windows. At the time, we didn't realize that it was only a recommendation. We thought it was a requirement. So we refinanced the property to take out the funds to afford the windows. Anyway, we went through all of the steps to get the new windows approved and then proceeded to replace them. Once they were installed, the HOA decided that they were not in compliance and they told us to replace them by March 31st or they would fine us up to $250 per month. What are my options? I'm curious, just looking at the beginning of this, we didn't realize it was only a recommendation. That seems like that might be on the homeowner.
They said, "Oh, it's recommended," and they just, I want to make sure that I'm well taken care of, and they just jumped through and did it.
Yeah, so you'd have to look at the language. I don't know what they mean by an HOA recommended. At the time, we didn't realize it was only a recommendation. I mean, it's either a recommendation or a mandate.
Yeah.
So I don't know how much they can plead ignorance on something like this. Although if you had, I'll put it this way, if you had a document that came from the association, had the association letterhead saying, "Dear homeowners, we recommend this amazing window company. They are phenomenal." And you go so far to actually install those, and now they're flipping it and saying, "Hey, they don't comply." I would argue you might have what's called detrimental reliance. You relied upon the board, even though it was just a recommendation. You know, they shouldn't have recommended stuff that didn't comply in the first place. And to the extent that they're like, "Oh, we screwed up," well, that sounds almost like a negligence. They were negligent in that flyer, and now, you know, to ask that they remove it, that's kind of BS.
Yeah, there's
right?
a lot of
So-
ambiguity here.
Yeah,
Right.
so
Because it
there's
could have
too
been-
much ambiguity. I would have to dive into this further, but they might have, just looking at the face of it, you have this notion of detrimental reliance. You said, "Hey, this is under board authority. You recommended this. We went through the rigmarole of refinancing our house, installing these windows. And so now that you want us to rip them out, I believe that there would be a good argument to say, no, we're not ripping them out. We relied
And it
upon
says
what
we
you
went
said."
through all the steps to get them approved. I'd like to see the steps.
That's
Yeah.
the
Again,
There
though,
must be written
I don't even know what that means,
trail
but
for
let's
that.
assume for a second that they went through an architectural control process. They probably could fight back pretty
Sure.
aggressively.
Yeah.
There's something more to the story, though, that they're getting fined up to
100%.
$250 per month. So I don't know. Maybe there was a recommendation. Well, I don't know what the approval process means. I mean, does that mean that the president came by and high-fived them and said, "Hey, these windows look great"? Or
Yeah,
does it
there's-
mean that they went through the architectural control committee and they have a rubber stamp? Or-
There's
Right.
a lot of ambiguity here that
So,
interesting.
Are we going to keep going?
yep.
All right. Let's see.
Oh,
Ever worth appealing a fine, or does it put a target on you? I had someone park against the rules on my property and I'm getting fined. Not my vehicle.
Yeah, so I think it is worth appealing a fine. Yeah. And if you then get targeted subsequent to that, then you have a bad HOA and you could probably kick back for retaliation.
Nice.
Mm.
Okay.
Easy.
The next one says, parked in the street over at my friend's house, and when we came back a few hours later, I had a ticket posted on my windshield from the HOA. If they do end up mailing me a ticket, I'm curious how legally enforceable it actually is for me to pay it.
So the ticket is valid if it's authorized by the governing documents. So it's just like any other fine. I mean, if you leave your trash cans out for an extended period of time, eventually you're going to get a fine for that. It sounds like their ticket procedure is similar to that. It's probably written somewhere, and I would imagine it's fairly valid.
Okay, interesting. So let's hypothetically say, I don't live in the association. I'm just a guest. I park somewhere I wasn't supposed to park. I get a ticket, and then they're ticketing me, or are they ticketing the homeowner? I'm assuming they're ticketing me.
Homeowner.
Oh, they're going to ticket the homeowner.
Yeah.
For their guest.
Correct. Yeah, that's going to tether to you.
Okay, I was
not to the individual, because the individual, the third party, isn't bound by the CC&Rs.
Yep. Okay, that's exactly what I wanted to get clarified.
Yeah.
But what if they don't know who it? So the trouble that you can get into is we don't know whose guest the vehicle goes to.
That sounds like an association problem to figure that out.
Exactly.
And if they can't pin it to a home, then you might have a problem, or the association might not be able to collect on that.
Understood. And that's when they could have a potential illegal violation of those CC&Rs on the flip side. Okay, understood. All right, let's keep trucking along.
All right, this next one has an emotion
month.
tied to it. I know. Today we got a notice and a $9 fine for parking on the street during the day, which literally every single person in our neighborhood does. The notice shows they assigned the violation on the 10th, and if not corrected by the 20th, we would receive the fine. The notice arrived via email on the 25th. In addition to that, the notice informed us it was specifically 3.16 and 3.17 we were violating. I'm assuming those are codes. No such sections exist in the bylaw handbook. Well, there you go. You answered your own
Well,
question.
first, maybe 3.16 and 3.17 tether to a different document and not the bylaws.
The CC&Rs.
Yeah.
They said they have the bylaws, but as we found out, those are two separate things.
They might be
Right.
cross-referencing the wrong set of documents. Hold on.
And if it arrived on the 25th,
They might be able to challenge it just on a technical basis.
That they received it on the 25th.
Yeah. And just if they could just show it, that might be if they run it through an IDR and just show the timeline.
Yeah.
But
And then the other thing is, it sounds like this is potentially selective enforcement.
yeah, that's the other thing that I was going to say. So it's one thing. Let's say everyone in the neighborhood does this, but everyone gets ticketed. You don't have an argument.
Yeah.
If everyone in the neighborhood does it, but you're the only person getting the ticket, you might be able to push back.
Yeah.
Why am I the only person getting ticketed? Selective enforcement.
Yep.
Or and the same on the other side of that coin is preferential treatment.
Sure.
So, however you want to articulate
All
it.
right, last one.
Is there a legal limit to how much a homeowners association can fine its members, irrespective of what community's covenants, conditions, and restrictions stipulate? It's not about what's reasonable, it's about what's legally permissible.
Irrespective of the community's covenants. So
Is there a law that puts a cap on how much they can fine? Probably on an individual level and a cumulative.
oh, that's interesting. That I don't know.
Haven't come across that?
I've never challenged a fine based upon it being above a statutory limit. I've never seen that come up. So I don't know.
Interesting.
Interesting.
So you stumped me twice today. I do not know that. Typically, fines are set forth within the CC&Rs. If they go above what's set forth in the CC&Rs, there's an issue.
Sure.
Yeah.
But to come in and say that the fine is in violation of a statute, I've never had to do that. So I don't know. Maybe.
All right.
I'd have to research it.
That was a juicy episode.
Yeah.
A lot of good
That was
stuff in
good.
there.
All right. So next week we have failure to repair.
We covered a lot of that, but we're going to we'll deep dive into that one.
Yeah, failure to repair is huge.
Yeah.
That's a very hot topic. So thank you guys for being here today.
Thanks for having
All
us.
right.
That was fun.
And thank everyone for watching. We will see you next week.